Oregon, how you doing tonight? How you doing tonight, Oregon? You're doing better tonight than you were doing last night, that's for sure. I'm Bill. This is Washington Law Live. Just going to kind of wing this thing here real quick. It's going to be a quick one. I'll try to get to some of your guys' questions after I'm probably done streaming the video itself and getting back to it. But hey, listen, Oregon, huge news. Listen, we've been on this journey together. We started like last September. I started covering Ballot Measure 114. I said this was absolutely the biggest pile of shit legislation I'd ever seen. And then it barely passed. I mean, ever so narrowly. And if it wasn't from Multnomah County, it would have failed miserably. Judge Ratio down there in Harney County did you all a solid way back in the day. He temporarily enjoined this law, so you haven't had to live under this magazine ban. You haven't had to live under this horrific pre-purchasing licensing requirement. And yes, guess what? You're still not going to have to live under it because Judge Ratio today has issued a permanent injunction enjoining all of Ballot Measure 114. Okay, that is a permanent injunction. So what does it mean? What does tomorrow look like as opposed to today? It really looks the same in the sense that because you've never been subjected to any of this yet. But we'll talk about that here in a few minutes. But this is the important thing. As you guys know, in Ballot Measure 114, there was two real main components, okay? And for those of you who really geeked out on the ballot measure, you would remember that sections 1 through 10 all dealt with the pre-purchasing licensing requirement. And then section 11 was your magazine capacity, okay? And so what the judge has done here is he has struck down both provisions, okay? He's found Ballot Measure 114 in its entirety to violate the Constitution. And we're not talking Second Amendment analysis. If any of you geek out, and I will tell you that I already shot a video, a more polished video. Well, I will try to polish it up. You polish a turd up and try to make it look good. But I will get a video out tomorrow morning. It'll be out tomorrow morning at 9 a.m. West Coast time. And I will go through this ruling in much greater detail. I'm going to give you guys some nuggets tonight. And then you'll see some of the same stuff repeated on the video. But we'll have a chance to geek out on this again. So here we go. This is exactly how it starts out. The Harney County Circuit Court is issuing a permanent injunction under Oregon Revised Statute 28.020, declaring the 2022 Ballot Measure 114 unconstitutional, thereby permanently enjoining its implementation. All right, that is fantastic. Now, for those of you who are actually going to geek out on this, not rely on my words, but go do the reading yourself, the judge did get into very, very thorough, detailed historical analysis. Now, I said that this case was decided completely under Oregon law. It was. You will see citations in here that are only to Oregon case law. And the only thing that's being cited in here is Article 1, Section 27 of the Oregon State Constitution. So the likelihood that this particular ruling could end up in the federal courts is virtually impossible at this point. Please understand that the appeals on this will either have to go to the Oregon State Court of Appeals or the Oregon State Supreme Court. That's really as high as this could go. This is exclusively a state question. There's no Second Amendment analysis or anything like that. Now, Oregon, Article 1, Section 27 does provide you very similar protections than the Second Amendment. So you do have benefits there. Just for those of you in Oregon who really want to geek out, your constitutional amendment, Article 1, Section 27 reads, the people shall have the right to bear arms for the defense of themselves and the state, but the military shall be kept in strict subordination to the civil power. Now, Judge Ratio, as I said, he went through a very extensive historical analysis to figure out what sorts of traditions, from a historical standpoint, would Oregonians anticipate to have as gun restrictions. And he went back to the formation of the state of Oregon and the ratification of the Oregon State Constitution. And he looked very carefully at the lifestyle that the state of Oregon had in that time, because that was real pioneer days. I mean, you didn't have it all cushy now where, you could smoke heroin on one corner and take a dump on another corner and call it Portland, Oregon, okay? But the court here specifically found that the court finds the metal cartridge, percussion cap, ignition, and repeating technology, along with the development of detachable magazines in the 1870s, firearm automation, and smokeless powder in the 1880s, were at the foundation for the semi-automatic firearm. And he finds that these are exactly the types of firearms that those who found Oregon would actually anticipate people to use. In answering the question, Judge Ratio said that the question for the court to answer is, what did the voters of 1857 understand Article 1, Section 27 to mean? The answer lies with voters heavily reliant on firearms for their basic subsistence and protection, voters engaged in forcible removal of indigenous tribes of Oregon, which the settlers described as war, in which they engaged in militia-type service, voters who wanted the very best weapons they could procure for those purposes, and a clear lack of governmental restraint on the types of weapons available to the public, both private and military grades. The court finds the voter of 1857 did not seek to restrain access to the best firearms with the highest functionality possible they could procure. Very, very true. Congratulations, Judge Ratio. That's a good reasoning. Now, to give you an idea, a little tongue-in-cheek on where the judge was going to go with this pre-purchasing licensing. Let's talk about the pre-purchasing licensing. And let's, for any of you who have friends who believe like, well, you know, hey, you need a license to get a car, you need a license to hunt, you need a license to fish. Why shouldn't you need a license to get a gun? Remind them first that hunting, fishing, or getting a car is not enunciated anywhere in the Constitution whatsoever. The right to keep and bear arms, however, is. It shockingly comes right in after the First Amendment. But the other thing is that, can you name any other constitutional right that you actually need government's permission? Because that's what a license is, okay? A license is government's permission. It's like a hall pass. Your driver's license, my driver's license, that's a permission from government, okay? My bar license that allows me to practice law in the state of Washington is a privilege that's been granted to me by the state of Washington, a privilege that I had to earn by obtaining certain degrees, passing a certain exam, and not being a freaking idiot for the rest of my professional career, although Mrs. Kirk might disagree with some of that. Now, what the court said about this, let me say this real quick. So let me full circle. For those of you who get in debates about this stuff with your more liberal friends, just ask them this question. Listen, you know, everyone has the right to go to whatever church or synagogue or house of worship they want on whatever day of the week they held services. It's called the freedom of religion. Nobody needs a license or government's permission to decide what church they go to. We all have the right to speak freely. Do we have to get government's permission to do that? We have the right under the Fourth Amendment to be free from unreasonable governmental searches and seizures. Do we need to have government's permission? Do we need to have a license before we actually get to enjoy that right? Under the Fifth Amendment, you're not forced to testify against yourself or incriminate yourself. Do you have to get a license for that? No, that's not how it works. Under the Sixth Amendment, you have a fundamental right to due process and representation of counsel. If you are charged with a crime, do you need a license for that? No, you don't. Hey, under the Eighth Amendment, you are free from cruel and unusual punishment. Do you got to get a state permit, though, to be free from that? No, you don't. So if anything else in the Bill of Rights operates in that fashion, why then would your Second Amendment rights, also in that long list of inalienable rights, you know, the ones that your creator gave you, and that the Second Amendment basically just says they cannot be taken from you by government. People need to understand the Second Amendment doesn't give you the right. You were born with that right. The Second Amendment guarantees that government cannot take it from you. It works that way for the First Amendment. It works that way for the Fourth Amendment. It works that way for the Fifth, the Sixth, the Eighth. Many of you probably also know the Third Amendment, right? Of course you don't. No one ever talks about the Third Amendment. That is, government cannot force you to house soldiers in your home. There's your worthless piece of trivia. That and $2.50 will get you a cup of coffee. Okay. The court said this about the permit to purchase, okay, which is, hey, even if I could have a line item veto, if I could just scratch some of this out, I still couldn't make this thing constitutional. Court specifically ruled the court does not hold a line item veto, allowing it to redline language of ballot measure 114 to make it read in a constitutional way. Such an act of judicial power would be a true arrogation of authority reserved for the legislative branch. Sections 1 through 10, that's your pre-purchase and licensing, each and all contain the language permit to purchase or permit, both in titling and of the section, both in the titling and of the sections of the language within the body of the text. The court cannot practically rewrite those statutory changes to make them constitutional. Okay, the state of Oregon, when you guys start geeking out on this, I'm going to tell you that one of the things the state of Oregon did, and if any of the Oregon state attorneys are watching this, welcome to the channel. You guys absolutely shot yourself in the foot, okay? Because they stipulated the 3 facts, and those 3 facts ended up coming back and absolutely cooking the state of Oregon. Here's the 3 facts that the state of Oregon was willing to stipulate to. Number 1, that ballot measure 114 delays the purchase of a firearm for a minimum of 30 days. And guess what? Judge Ratio believes, as we all do, that a right delayed is a right denied. Boom. Okay, but that's not what cooked them. Okay. 2, that the permit to purchase program derives its language source in the concealed handgun license statutes in Oregon. That's right. So you're basically having to go through a background check to go through a background check before you get to go through a background check. That's literally what the state of Oregon had set up. But this is the critical one. Okay, this is the critical one. 3, the Federal Bureau of Investigation refuses to conduct criminal background checks. That is true for pre-purchasing licensing. Yeah, they'll conduct a background check when an FFL calls in and says, hey, I got a guy trying to purchase a firearm. Yeah, that's how the NICS system works, okay? But when the state of Oregon calls and says, hey, we just want to check and see if this guy's cool enough to buy a gun. Oh, what kind of gun is he? Oh, I don't know. He's not buying a gun today. He's just, we just want to see if he's cool under our standard. They're not going to run those background checks. The FBI they can't even run the number of background checks that are coming in on firearm purchases. They're not going to run it for some quack state that wants to do these permit to purchase licensing things. Okay. So this is what you need to be aware of, Oregon, is that what the judges essentially ruled here is, yeah, listen, you just said it was going to be delayed. You actually also stipulated the fact that it's virtually impossible. A right delayed is a right denied. You lose. It's an excellent ruling by the judge. The other thing is that, think about this, and this is a line of reasoning that I hadn't really thought of, and I kind of feel kind of stupid for not thinking of it. But Oregon, if you take a look at any of your self-defense statutes, and for all my hometown crowd here in Washington that are geeking out with us tonight, welcome. Thank you for being here. But this is the case in Washington State too. And for around the country, this is, if you look at your self-defense laws, okay, just look at your self-defense laws. Guess what? There has to be some kind of an imminent threat before you get to use force, okay? And if it's an imminent threat of death or serious bodily injury being used upon you, you actually may have the right to use lethal force. But that threat needs to be imminent. It could happen at any moment. Now, think about it. If that's the standard by which you can then use force, why then does Oregon law prevent you from being able to use force for at least another 30 days? The threat itself is imminent. And so that whole question, well, who would ever need a gun right away? And for those of you, again, who got people who believe these waiting periods save lives, who would ever need a firearm right now? I would point to any Jewish American right now in the United States, especially if they're on a Ivy League college campus. So here's what the court said. The court further finds that the 30-day absolute prohibition on the initial purchase of a firearm is not permitted under the Oregon Constitution. Okay. The court finds there are no reasonably likely circumstances in which the application of ballot measure 114 sections 1 through 11 would pass constitutional muster. So for those reasons, down goes your pre-purchasing licensing requirements. More stuff in here about the background checks. And finally, what I would say, just again, this is what the court had to say on pre-purchase licensing. We still got to get to part 2. The court reiterates its finding that the significant delay imposed by ballot measure 114, the enactment of a rational basis policy on a right that requires the deference of intermediate scrutiny, the inability of defendants to institute the policy as written with no FBI background checks, and failing to demonstrate the ballot measure 114 permit to purchase policy promotes public safety, all of which unduly frustrate the right to bear arms. So down goes the pre-purchasing licensing requirements. Hallelujah. Now that's only half the good news, because there's more. The more is that the magazine ban has also been struck down as constitutional. Judge rules magazines, along with the rest of the firearms components, are protected arms under Article 1, Section 27. There is no historical basis for limiting the size and capacity of firearms, including their magazine. The history that the judge relied on, again, going through rich Oregon history, deep into the Oregon history books here. As stated above, the conservative pioneers who voted for the Oregon Constitution in 1857 wanted the best shotguns, rifles, handguns, including revolvers and pepper boxes and muskets that they could afford. There was a deep desire to have repeating features. Arms consisted of those weapons used by settlers for both personal and military defense, excepting cannons and other heavy ordnance not kept by militia or private citizens. So that is the historical basis by which this judge is going back to take a look at it. Now, it's not often I get to say I told you so, and sometimes at home when I can say it, the audience would not be particularly receptive, so I will not say it at home sometimes. But I told you so. And what I told Oregon, you may recall this. If I had the graphic, I'd pull it up. It's possible to do on these live feeds. But I did a video way back when we were first geeking out on Oregon Ballot Measure 114. And I got to looking at the language about how they were defining magazines. And the problem is that the language they used on plugged magazines really meant that if that magazine could in any way, shape, or form ever be unplugged, which all magazines can, then really the state of Oregon was not going to permit the sale of any of those magazines. And unless every firearms manufacturer came out with proprietary 10-round magazines, which no firearm company is going to do that because it doesn't pencil for them, okay? That will not pencil at all. So what the court found, though, is that, hey, guess what? Washington gun law was right. Well, we weren't cited in this here. But I'm going to read this to you. I'm going to skip through it because it gets a little wordy here. But you're going to see what the court says here, which is that the distinctions, and when they're talking about the distinctions, is between how other states defined it and how Oregon chose to define it. The word change does not exist in any of the other states' statutory definitions, and pursuant to statutory construction, changed must have a different meaning than converted. The court finds that the expert testimony, this is, by the way, the state's expert testimony, showed demonstrably that the 10-round limited magazines on the market could be readily changed in under a minute's time to hold substantially more ammunition. So, yeah, for that reason, it would eventually, ultimately, I believe it would have banned the sale of any detachable magazine in the state of Oregon. That's whether the state of Oregon did that on purpose. I don't know if they're smart enough or nefarious. Well, they are nefarious enough. I don't know if they're smart enough to actually be that sinister and drafting in there if it was an oversight. I mean, obviously, when you read this legislation, and Washington's not unique to that, and neither is California, Illinois, any other of those other states, is clearly these things are never written by people who have even a rudimentary understanding of firearms. Fixed magazines, if any of you are worried about fixed magazines, the court finds almost all rifles with fixed magazines can, like shotguns, have magazine extensions added readily to increase the capacity of the rifle well over 10 rounds because of the same cleaning necessity and easy adaptability. Therefore, they will be treated not differently. Any ban against that is also unconstitutional. Law enforcement officers. Don't know if we have any Oregon law enforcement officers online. Maybe we catching it on replay later. Thank you for joining us. I said this on a video. I said, hey, listen, if you look at the language that's in this freaking bill, it allows police officers to be exempt from it while they're actually on duty in uniform in their patrol car. But the rest of the time, no, they can't be carrying anything more than 10 rounds when they're in plain clothes, not on duty, when they're in their own freaking home, for God's sakes, okay? And so what did the court say? Court said the court finds police officers would not be able to possess their duty weapons when at home because they would not be acting within the scope of their official duties. That's exactly right. Judge got that one right. That is another reason for which this statute has been struck down. Of course, Oregon came in with all sorts of, hey, let me show you some historical analogs. And what the state of Oregon really tried to do was just come up with more modern things. The defendants attempted to assert that the Section 11 ban would have a significant impact on mass shootings. but they failed to lay a proper scientific foundation. Now, if I got any other lawyers out there, okay, if the Pete Serranos from the Silent Majority Foundation or the Costas Moros out there down in California, Rob Romanos, guys like that are really doing a lot of heavy lifting litigation, you really got to check out the section in the opinion. It kind of starts over on page 38, really gets rolling on page 39, about Dr. Michael Siegel, the epidemiologist from Tufts University. This guy is nothing but a paid-for hack for civilian disarmament legislation. This guy would say anything if you threw a buck at him, okay? He's clearly an anti-gunner. I know I'm using language that I don't normally use on my regular videos. And the truth is, the guy's a turd of a human being. I mean, he literally has no moral compass. He would sell his soul. Court was not impressed with him either, by the way. And so the court found him not to even be credible. I don't even think the court admitted the evidence. I think it had been a jury trial. I don't think the evidence would have been admitted. Oftentimes, inadmissible evidence, judges will hear it anyways because they know how to properly attach weight to it. And the judge attached the exact amount of weight that he should have to this, which was absolutely zero. Essentially, the defendants wanted to come to court, say this person is an expert, and have the expert assert their legal conclusions as scientific evidence without the proper showing to the court of the scientific validation for the process or the way the process was used to come to that conclusion. The defendants failed to establish a factual, scientifically reliable record to allow Dr. Siegel's conclusions under Oregon evidence rules. That's Dr. Michael Siegel. I'm sure you're not watching. If you are, you, sir, are a hack. Okay, now I'm going to read the conclusion here. This is the conclusion from Judge Ratio. Declaratory judgment is preventable justice designed to relieve parties of uncertainty by adjudicating their rights and duties before wrongs have actually been committed. This court is preventing the undue burden of Ballot Measure 114 from being imposed on current and prospective gun owners who have a right to lawfully possess firearms for the purpose of defending themselves and the state against imminent threats of harm. Pursuant to ORS 28.010, the court, using its equitable power, declares and adjudges Ballot Measure 114 facially unconstitutional in all of its application under Oregon Constitution, Article 1, Section 27. The court makes this declaration to settle and to afford relief from uncertainty and insecurity with respect to the right to bear arms in Oregon. Ballot Measure 114 is permanently enjoined from implementation. Woo! Yeah, that is good news. Oregon, this has been a long journey. It's not over yet. That's the problem. But huge win. Huge win. Okay, why? Now, the normal course of appeal, state of Oregon right now is completely crapping its pants, but they should have known this was coming. They should have known. I mean, this judge issued a statewide injunction, which means what? There was irreparable harm and to a likelihood of prevailing on the merits, right? For those all you geek out on this channel here. And then remember, the Oregon State Supreme Court on 2 separate occasions said, hey, we're not even going to touch that injunction. We're just going to leave it in place. So Oregon Court of Appeals is where this should be taken. The state of Oregon may, for political reasons, and I have a pretty good understanding of how the Oregon bench is stacked up, may want to appeal this directly to the Oregon State Supreme Court. That's where this is going to get really interesting, okay? Because if the Oregon State Supreme Court really wanted to inject themselves in this, they've had 2 opportunities to do so already. So that's going to be interesting. Obviously, they are entitled to an appeal. So the state of Oregon is going to get an appeal on this, whether it ends up in the Court of Appeals or the Supreme Court of the state of Oregon. They will get appeal. Every party has a right to that. And here's the thing you need to understand. This entire argument and this entire ruling is based under Article 1, Section 27, Oregon State Constitution, and Oregon State case law. So you're not going to see this case kicked into the federal court. You're not going to see this case necessarily kicked in to the United States Supreme Court or anything like that, because this is really exclusively a question of state law. So this will be decided probably inside the borders of the state of Oregon. Okay, now the case, once again, I don't know why I can't remember it off the top of my head. I should by now. Arnold v. Kotek. There's a lot of named plaintiffs in here, but that is a fantastic case. Now, if you guys decide to geek out on tomorrow morning's video, which will look a little more polished, I will link this up down there so that you can geek out on it for yourself. And obviously, you can find it out there. It's not too hard to find. My copy came from journalist Michael Easton. He texted me. I'd actually shot 2 videos today in Cleellum. I was going to go back to Casa de Kirk here on the west side and get them edited. And then Michael Easton texted me. He was like, hey, check this out. Permanent injunction on ballot measure 114. The ruling didn't surprise me at all. I totally had expected Oregon to win. You deserve to win. Judge is a good judge down there, obviously. Of course, I get that as I'm, going across the state here. So I decided to jump in here, get the video recorded. I'll get that polished up and out tomorrow. Wanted to go live with all of you. We got, hey, Jesus, 1,400 of you. Hey, thank you very much to all of you for joining us. Now, listen, by the way, if you go up to the top of the text box, if you're interested in nominating Washington Gun Law for a Gundy, a prestigious award for all of the gun tubers, I did put a link up in the top of the text box. So we would love if you showed us a little love. Oregon, all the love belongs to you tonight. You deserve this. You've been through a tough time. As a Washingtonian, I can kind of appreciate what you're going through. But this is a huge ruling. Now, obviously, the state of Oregon will appeal. And so we'll be doing more videos, Oregon. We'll be doing more videos. As soon as there's more development on this, we will let you know. But for the meantime, hey, enjoy your freedoms, okay? Listen, to all of you, all 1,300 of you right now who tuned in tonight, thanks a million. I really appreciate it. Especially if you're not in the state of Oregon and you just like geeking out on this stuff so much, you joined us anyways. Thanks a million to all of you. In the meantime, let's everyone remember now, okay, that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. I'm going to end the stream. I will try to answer some of the questions that came out tonight, but it is almost 8:30, and I got to get back to Casa de Kirk and work on the more polished version of this. Thank you, everyone, for joining us, and most importantly, all of you, stay safe.